Be seated. Good morning, everyone. It looks like we're ready to go. We have one case on the docket this morning. I'm Judge Thomas Malone. To my right is Judge J.C. Hurst, and to my left is Judge Angela Coble. We are the panel for today's specially set case, and we'll go ahead and proceed with that in a minute. Let me start off by saying, first of all, counsel, you can hear me, I take it?
Yes, Your Honor.
All right. And we'll go ahead and proceed with this one case. Let me start off by saying that we have read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind as you present your argument this morning. As the presiding judge, I'll be the timekeeper. Each of you is given 15 minutes for this case. The appellant's attorney should let us know at the beginning if you wish to reserve any time for rebuttal. After you make your argument this morning, your case will be deemed submitted for decision. And after that, we'll take the case under advisement and get a written decision out to you and your clients just as soon as we can. So with that, I'll go ahead and call the case. It's from Sedgwick County. It's number 125-511, Credit Union of America versus Robine Elaine Lunkwitz. I hope I pronounced that correctly. And Ms. Lunkwitz is the appellant. And who do we have appearing for her today? Counsel, you're muted.
Yes, Your Honor, David Herron appears as counsel for the defendant and appellant Robine Elaine Lunkwitz.
And for the credit union?
Your Honor, Nolan Wright appears for the Applee Credit Union of America.
All right, thank you, counsel. Mr. Herron, do you wish to reserve any time for rebuttal?
3 minutes, please.
That is granted, and we're ready to proceed.
Your Honor, this case hinges on one main issue. Although 4 issues on appeal were raised, each of those issues will stand and fall on how the court treats the filing submitted on July 1st. Indeed, on July 1st, I, as counsel for Robine Lunkwitz, had seen that a summons and petition was sent to an address in Chicago. So I filed a paper specifically stating service of a summons is not waived. It did contain the verbiage or the title, Your Honor, that said entry of appearance, but went on to explain this is a limited appearance for the sole purpose of challenging whether personal jurisdiction exists. So all 4 of my issues raised in the brief admittedly stand and fall as how does this court treat the filing of that paper? Does it comprise a voluntary appearance which waives the service of a summons, even though the paper itself says service of summons is not waived? I do concede that the limited actions code does not contain many of the provisions of 212, 60-212, which allow a party to raise these issues in an answer. However, the limited actions code does contain the verbiage identical to the 60 code, which specifically maintains a voluntary appearance acts as service of process on the date it is entered. What does the phrase voluntary appearance mean under the 61 code is a crucial deciding point here. Your Honor, I assert to you that the legislature meant voluntary appearance under the 61 code. It's the exact same verbiage that was used in the Chapter 60 code. So our appellate court's decisions which construe that phrase are certainly instructive here. A voluntary appearance means entry by the defendant for the purpose of availing itself as a party to a dispute.
I'm a little confused about your argument in your brief and to the district court. As I understand, the district court found that your entry of appearance did not comply with Rule 115A. Is that correct?
Yes, that's exactly what Judge Turnus said.
All right. Now, on appeal, are you conceding that that's correct?
I am conceding that Rule 115 was not complied with. However, it was error to find that jurisdiction attached based on the failure to comply.
You're saying that Rule 115A doesn't even apply here. Is that what your argument is?
In essence, yes.
Just one other follow-up question. When you were at the hearing, it seemed like you were mainly arguing whether there was service and the entry of appearance qualified as waiver of service. The judge disagreed with that. At any point, did you then ask to file an answer out of time, or did it even get that far?
That request was not made to the trial court because the insistence was there's no jurisdiction over this dispute in the first place. We wanted this issue, this narrow issue, preserved for review rather than to address the merits of the petition.
All right.
And indeed, Your Honor, Judge Turnus did just grant judgment at that point. I never did attack it by filing an application to vacate the default judgment in the trial court, if that's what the panel is asking.
I did have a question about that. So you filed this document, which is, we're disputing exactly what it is here today. But then within the time to answer, did you file anything related, further contesting jurisdiction?
No. Other than the statements Judge Hurst made at that hearing that you see in the transcript. Right, no filing was made.
And counsel, so just help us understand. So you're conceding this was not a limited entry under Rule 115A, or a general appearance that would waive service, but there's kind of a question about whether you're asking us to consider this as some sort of motion or other type of I mean, what sort of pleading is this? I mean, how do you describe this pleading under 612903 under the types of pleadings allowed in a limited action? What is it?
It does not comply with Rule 115 because it did not intend to comply with 115A. Our position is, Ms. Lunkwitz's position is that limited rule does apply to limit the scope of a lawyer defending a party over which the court already has jurisdiction. The threshold issue of jurisdiction over the party must be addressed before any substantive matter can be addressed. This paper served the limited purpose of informing the court, we don't think there's jurisdiction here to do anything, Your Honor. That's what the purpose of the filing was. However, inartfully, and I wrote it myself, so I have to admit it was inartfully done and could have been drafted a little more carefully. However, the substance is clear. Service is not waived. We cannot go forward with the application of any statute or application of any rule or the granting of any relief in this matter until we attach personal jurisdiction to Robine Lunkwitz. My purpose of
counsel, though, once something did happen, once the court did start acting in a way that you believe was contrary to personal jurisdiction, you did have the opportunity to file motions objecting to jurisdiction.
Yes.
And that's typically what you would do, right? If you think service has not been perfected, you would file something that says that.
That is correct. However, I'm sorry, I didn't mean to
go
catch you.
ahead. Go ahead, counsel.
Did this lawyer have the authority to defend the merits of the action is another underlying question. And the answer, according to this record, there is no,
Well, I don't mean the merits, sir. I mean jurisdiction.
was jurisdiction attached and where can it be attacked? We made a strategic decision that attacking jurisdiction in the District Court of Sedgwick County would not be the place to attack it, but instead to attack it in the Court of Appeals. Either place was an appropriate forum for that particular issue. And Robine Lunkwitz chose to make this attack in Topeka rather than Wichita. Well, actually, you're sitting in Wichita now, aren't you? I think.
We'll
There,
have a few minutes, counsel.
the bottom line is that a court is required to construe a statute generally with the intent of the legislature in mind. This provide and also apply the law to the facts in such a way that doesn't give absurd or illogical results. It's quite illogical, Judge, to claim that a party has waived service by filing a paper that says I don't waive service. That would be an absurd result and a wooden application of the law and the facts to this particular case. What I ask you to do is remand this case back to the District Court of Sedgwick County with instructions to deny the motion for default judgment and let the case continue on if they could if the credit union could indeed obtain jurisdiction over this defendant.
All right, counsel, thank you for those arguments. Mr. Wright, we will turn to you.
Your honors, may it please the court. Counsel for the appellant is correct that this case rests on the single issue, whether counsel's entry of appearance or document entitled entry of appearance granted the district court jurisdiction over the appellant. And if this panel reviews the applicable statutes and case law, the answer to that must be yes. The appellant's attorney has addressed many times that stating that this court cannot apply these statutes that say that a entry of appearance shall act as service of process in this manner because that would be an absurd application of the law. However, that is in direct contradiction to the court's holding in the case cited in my brief, I believe it's a Carvalho case, Fisher v. De Carvalho, stating that this court cannot add or subtract language in order to make the law what it believes it should be when it thinks that there is an absurd application of it.
Let me, counsel, let me backtrack just for a minute. You started off by sending the summons to a law firm in Chicago, no less, as I understand. I presume there must have been some correspondence with Ms. Lunkwitz's counsel before you even attempted to do that, right?
Yes, Your Honor, you're correct. I had received a letter from Mr. Heron stating that the appellant was requesting that we not contact her directly and instead have all communications through her counsel, Mr. Heron's law firm, which principal address is that address in our initial petition and summons. We then sent that summons to that address and received a letter back from, or an email from Mr. Heron stating that they would not accept summons on behalf of their client.
So there was, I don't want to get outside the record here, but there was never an agreement, obviously, by counsel that he would accept the summons as services, correct?
That's correct.
All right, and so clearly the record doesn't show service on Ms. Lunkwitz. So as you say, This case all boils down to whether or not the entry of appearance qualified as a general entry of appearance that waived jurisdiction, right?
Your Honor, I would dispute that. I do not believe that this boils down to an application of Rule 115A. I think that does have some application to this case, maybe later on in execution, as to how the defendant or the appellant can be served, whether or not it has to be on her attorney or both her attorney and herself. However, in this instance, either a limited entry of appearance or a general entry of appearance, there is no distinction in the statute. Both 61-2902 and 61-3003 clearly state that an entry of appearance, not limited or general, an entry of appearance shall have the same effect as service on the defendant.
So your main argument is Chapter 61 doesn't allow limited entry of appearance?
No, I think a limited entry of appearance is perfectly allowed. I think that if a defendant's attorney were to file an entry of appearance or a limited entry of appearance before contesting jurisdiction, I think waiver is a bad word here, because like the 10th Circuit distinguished, there is no defense to waive, because the entry of appearance, limited or general, would give the district court jurisdiction.
Well, I'm a little confused, and I'm sure this is my fault. But Mr. Herron filed a document, and he says he's entering a limited appearance for the sole purpose of examining jurisdiction. Service of summons is not waived. What could be clearer than that?
Your Honor, I would point you again to the case Jenkins v. City of Topeka. It's 136 F 3rd 1274, specifically the Penn site 1276, the 10th Circuit case, where it explains in examining KSA 6203, the analogous Chapter 60 statute, that there is no the analysis of whether or not there's been a waiver of the defense of personal jurisdiction isn't the case here. You cannot waive or preserve a defense that does not exist, and that defense does not exist when you file an entry of appearance. The proper form.
Counsel, we have a litany of case law that permits attorneys to enter an answer for the purpose of fighting jurisdiction.
Yes, Your Honor, and that would be the proper way to contest jurisdiction, would be to, or one of the ways would be to file a pre-entry answer that would state that the court does not have personal jurisdiction over the defendant.
But the attorney could show up to the hearing and say there is no personal jurisdiction, and would necessarily have to enter their appearance to speak.
Exactly, Your Honor. There's no requirement that Mr. Herron had to file an entry of appearance in order to either file an answer or file a motion with the district court that contested personal jurisdiction.
So your contention is that if he hadn't titled this entry of appearance, this would be fine?
It's my contention that if Mr. Herron didn't enter his appearance, the court wouldn't have gained personal jurisdiction over the defendant by virtue of KSA 61-2902C. So
I thought your main argument was that this entry of appearance didn't comply with Rule 115A to qualify as a limited entry of appearance. Are you saying that that's not your main argument?
Your Honor, as I stated earlier in this argument, I don't think it's material for the purpose of whether or not there's personal jurisdiction. And frankly, it's moot in this case because Mr. Herron has already agreed that he did not follow the Kansas Supreme Court Rule 115A. And therefore, if this is an entry of appearance, it is a general entry of appearance. So I think that that point is really moot here. There's no contesting that this was not a limited entry of appearance. Mr. Herron has stated as much both in his brief and here before the court. The real issue here is whether or not this court will affirm the district court's finding that Mr. Herron filed an entry of appearance, and this panel must, after reviewing the entry of appearance, find that he did. I mean, this looks like an entry of appearance. It walks like an entry of appearance, and it quacks like an entry of appearance.
Well, I disagree with all that. It looks like a limited entry of appearance, quacks like a limited entry of appearance.
So, Your Honor, Mr. Herron has already conceded that it is not a limited entry of appearance.
Well, he conceded that it didn't comply with all of the portions of Rule 115A, but it very clearly questions jurisdiction.
This entry of appearance, to the extent that it even raises jurisdiction, only states that it wants to examine jurisdiction. There is no objection to the jurisdiction. The literal language in the entry of appearance states for the purpose of examining jurisdiction. So, Your Honor, as I address the appellant's arguments that the court should liberally construe its pleading in the same manner as a court would do with a pro se litigant, if the court were to grant that leeway, Your Honor, the appellant's attorney's entry of appearance still fails because the substance of that entry of appearance does not comply with what is required under a pleading, as pointed out by Your Honors, under 61-2902, the papers allowed to be filed within the Chapter 61 court. It does not request any relief of the court. It does not set a hearing. It does not state particular grounds upon which relief should be granted. So the substance of the entry of appearance also does not get the appellant there. Further, I just want to briefly touch on the intent of the legislature. And Your Honor, I think if we want to look at the intent of the legislature and read 61-2903C with the statutes in Chapter 60, if you look at the analogous Chapter 60 statute, that's 6203, that statute does particularly give one limited circumstance where an attorney can file a paper with the court and it does not waive personal jurisdiction. And that is in the instance of preserving the rights of a litigant under the Service Members Civil Relief Act. And I do not believe that this court can add similar language to the statute 61-2902 that states that a litigant can preserve or it is not an entry of appearance in order to attack personal jurisdiction for all litigants. When you have this specific carve out in the analogous Chapter 60 statute, if the legislature wanted to have a carve out for a paper in order for a lawyer to present themselves and still defend personal jurisdiction without creating it by filing an entry of appearance, they would have put that language there. The legislature has shown that it is well within their ability to do so, and it did actually do so in the Chapter 60 statute.
Nothing further.
All right, counsel, thank you. Mr. Herron, I believe you still have 3 minutes of rebuttal.
I will be brief. Thank you, Your Honors, for taking the time to read the briefs and prepare with these penetrating questions. First of all, in response, I would like this court to determine that the issue of personal jurisdiction is a threshold issue, which must be examined separately before any other statutes are applied. Before you can leapfrog into applying the substantive law or even other procedural law, we must examine whether we even have the power over this person to do that.
And that's examined though by looking at the statutes. I mean, the statutes confer personal jurisdiction, right?
The statute is one source also. Were you finished?
Yes, I am sorry.
Oh, okay. My point is that service of summons does serve two main purposes in the law. First of all, compliance with the statute, but also a constitutional provision of notice of an action against one party. So even if a statute might be complied with or arguably in clash with another, there's still the constitutional provision that a party is entitled to notice of an action. Robine Lunkwitz was never given a summons. Is it fair under the Constitution to grant a judgment against her and give the credit union the right to zap her wages or take her property? The constitutional threshold hasn't been met in this issue, even if the statute has.
All right, counsel, thank you very much for your briefs and your arguments. As I mentioned earlier, we will take your case under advisement and get a decision out to you just as soon as we can. So with that, the hearing is